Welcome guys. This is going to be part 2 of the Remedies series. So in this video we are going to be tapping into the institutions that resolve disputes. So for this dot point you need to know the 3 different types. We're going to be looking at the role of a jury in a civil trial, which is very similar to criminal law. And we're also going to be looking at the difficulties faced by different groups in the civil justice system. And for the purpose of keeping this video nice and short, I'm just going to be focusing on young people. So first of all, just remember this very first dot point. It's important that you do know there are 3: tribunals, ombudsmen, and complaints bodies. And it's really important for this particular dot point that you know an example of each one and you know what the differences are between each one. But in general, speaking about these ones, these sort of 3 that we're going to look at are still much cheaper and much more time efficient compared to going to court. So I guess in a SAC, if you see what is another institution available for the party, you're thinking about these 3 here. So these are places you can go to have your dispute resolved, versus if you see what's a method to have the dispute resolved, you're looking at mediation, conciliation, and arbitration. So a lot of people get confused between these 2 dot points here. I guess from the start, just make sure, common mistake I see is when they see institutions, you know, that you got to make sure you talk about these 3 here. A lot of people, when they see institutions, they might talk about these, but just don't get that confused. So tribunals are a dispute resolution body which is very inexpensive and I guess a way that's much more time efficient to resolving a dispute. But one thing I kind of want to stress about tribunals is they're generally for your less complex civil cases. So if your dispute involves a significant amount of money, or it is very complex and involves lots of different parties, this is probably not the place for you. So it's only for your sort of lower scale disputes. So the example we're going to look at, which many of you might use once in your life, which is very common, is what's known as VCAT. And they're a very cheap, accessible and efficient body. So what's really good about VCAT is that most of the hearings are less than $100, and in some instances they are so good that they can waive that hearing fee altogether if you have financial hardship situations. And what's also really good about VCAT is they first try and use dispute resolution methods such as mediation first. So remember that neutral party, they're trying to use that first to help resolve disputes. But if things get too escalated, what's really good about VCAT is you can go to a VCAT hearing if these things are unsuccessful, and they can make a legally binding dispute settlement for you. So VCAT, they kind of hear 4 main types of cases, and they hear over 90,000 disputes a year. So what to think about with this here is, because they're seeing 90,000 people a year or 90,000 cases, it's taking a lot of pressure and strain off the court and their resources, which is really good. So your most common one they see is residential tenancies. So what this is disputes between a landlord and a tenant. For example, you know, you're a tenant and you have a really moldy bathroom and your landlord is not fixing it or refusing to fix it. You could take your landlord to VCAT to help him force a decision to get your bathroom fixed. So really good for young people, really good for people that may not be in the best financial position, and good for people that just want a really cheap and time efficient way to resolve many different types of disputes. Next one we have here is an ombudsman. What is a clear differentiation between these 2 is this is a government official who investigates complaints from individuals against certain bodies. Once again, you can kind of see the theme between the 3 we look at today is that they're timely and highly accessible. And what we really like about ombudsmen is they're completely free to access. So the one we are looking at today, which is very commonly used in Australia, is what's known as the Fair Work Ombudsman. So very common, looking into issues where employers are not paying their employees the correct wage, they're not paying super correctly, or they're giving them the wrong idea about what their minimum wage should be. So I put a stat here just at the bottom here to kind of show you how many Australian workers are underpaid quite a lot. So it's really important that we do have bodies like Fair Work, because they can help investigate issues and reach a settlement to help enforce, I guess, employers to pay what they're meant to be paying to their employees. All right, last one we have is complaint bodies. Key differentiation between these and some of the other ones we have looked at is that they are established by Parliament. And what they're looking at is helping individuals who have a specific complaint about a specific matter. So what complaint bodies are often looking at is issues relating to goods and services, or selling goods and services, or when, for example, a certain service that is offered is not as it is described. So with complaint bodies, one drawback or one downside of complaint bodies is they often cannot make a legally binding decision. So I guess this can be seen as a weakness because you might get a really positive outcome through a complaint body, but the other side doesn't necessarily have to follow it, unless a contract or an agreement is drawn up. So the example we have is what's known as Consumer Affairs Victoria. Pretty much any single time you have an issue with goods or services, this is the place to go to. So what's really, really good about Consumer Affairs Victoria is they are completely free to access. So, if you're a young person, if you're an older person who doesn't have much financial capacity, this is a really good place to go. So for example, if you had a fridge that you bought, for example, and after 3 months it broke, and the store you bought the fridge from was refusing to replace it under warranty, even though it's still under warranty, you could go to somewhere like Consumer Affairs Victoria, and then they'll chase up the fridge supplier for you. So it avoids that whole hassle of everything going wrong. Another common one that a lot of people will be faced with is that they get faulty goods, things that are broken out of the box, things that weren't as they were described. You can go to somewhere like Consumer Affairs and they will chase it up for you. Moving on to the role of the jury. What's really good is the role of the jury dot point is very, very similar to civil law, but there is just a couple things I wanted to stress before we get stuck into the roles to make sure you are pretty consistent with your answers. So first of all, in the Magistrates Court, just like in criminal law, there is no jury whatsoever. When you go to the county or Supreme Court, it will either be a judge-only trial or a judge and a jury. So that kind of takes me to my next slide. One really important thing to note about this particular area study is that parties actually get to choose whether or not they want to use a jury. So what's really important to know is if in a SAC, for example, you get a case study that mentions that there is no jury, for example, and you're getting asked why there is not a jury, it's probably because the parties have said, no, we do not want to have a jury. So I guess what I'm getting at here is juries are completely optional in civil law, which is very different to criminal law. And the second biggest difference about the juries is that there is usually 6 to 8 jurors in a civil case versus criminal law where there is 12. Okay, so moving into the roles, I'm going to present to you 3 kind of general roles of the jury. There are obviously a few more, but I generally always remember for a SAC just to remember 2 or 3. First one, obviously, they're there to hear both sides of the case. They need to listen to the evidence as best as they can, and after all the proceedings and all the hearings have gone on, what their main real job is they need to make a decision. They need to decide whether that person is liable or not liable. And what they're doing as they're making this decision is they want to try and do it based on the balance of probabilities. So they're kind of trying to determine which side is more correct or which side is more probable. Second role of the jury is that they need to try and reach a unanimous verdict. So it's very similar to the first one. So just try not to overlap the wording too much. So they're trying to reach a unanimous verdict, and after 3 hours they will accept a majority verdict. So what that means is that if there are 6 jurors in a case, we are trying to get 6 out of 6 jurors to say, yes, this person is liable. But after 3 hours, they will accept 5 out of 6 jurors, for example. The last role of the jury, which I'd probably recommend using, if you're talking about 2 roles, for example, I'd recommend using the first and the third one, which is this one. So also, in some cases, they'll be responsible for awarding the level of damages awarded to the plaintiff, except for defamation cases. So defamation cases are the exception, where the judge will be responsible. But in many civil cases like negligence, the juries will have a role in determining the level of damages they believe is the best fit. Alright, moving on to the last key knowledge area. we had a look at this similar dot point here for criminal law, I think area study 3. One thing to note is that when you're looking at this difficulties faced by different groups, it's related to civil law for this one, obviously, and they have actually changed the dot points here. So you can see that they've removed a few and added a few. So we now have people with low socioeconomic added, and we also have people in remote regional areas. So for the sake of this video, I'm just going to be focusing on one of the groups, but obviously be guided as to what your teacher has said. You might have to know all 4, you might have to know 2, but just to keep this nice and short and sharp, I just want to sort of focus on just the one. So I'm going to be focusing on young people again, like I did last time, but kind of relating this one more so towards civil law. So first thing we need to know is we need to know some of the difficulties faced by your chosen group, and then we obviously need to know how they overcome those specific difficulties. So same as criminal law, a big issue faced by young people is that processes and procedures can be very, very complex. The whole legal system is very overwhelming, and there's a lot of different moving factors, which means people can have, I guess, difficulty engaging with the system. Another big common problem is that many young people are unrepresented, and why this is such a big issue for civil law is that there is a lot less funding for civil law in contrast to criminal law, which creates an even bigger barrier for younger people. So kind of what that means is, like, you have places you can go to, like Victoria Legal Aid, for example. There is nowhere near as much funding for Victoria Legal Aid in relation to civil matters compared to criminal law. So that can be a big difficulty faced by young people. The second one that they often face is lack of resources. Being quite young, for example, and by young people I generally mean people under the age of 25. So the biggest barrier for young people is their lack of financial resources. Most people under 25 will most likely be studying at uni, working in a trade, for example, apprenticeship, that sort of thing, or a traineeship. So they're not going to be in the best financial situation. Or even maybe some people may have just started working full-time and are finally on normal wages, but still they're not going to have a huge amount of money. So why that's a barrier is that they're often going to struggle to pursue a case if someone's done the wrong thing against them, or if someone sues them, they might not have the financial capacity to defend themselves. A really sad reality for some cases is that often people have had to take out loans to defend themselves in court, which is really unfortunate, kind of is a big difficulty. And for some people as well, some young people that have limited access to technology, especially those people in low socioeconomic backgrounds as well. So that can be a really big barrier for people, because it means that they might not have the knowledge to research how to actually get assistance when things go wrong in civil law. So how do we overcome those difficulties? We do have many institutions available to help young people. Just like criminal law, youth law is a really good centre we have for helping young people. Obviously with civil law, we see a lot of young people faced with these common issues like car accidents, workplace discrimination, or a really big one is landlord-tenant disputes. So this community legal centre has been set up to help those people. You can go here for advice, for guidance on how to defend yourself and what to do. So a really good way that young people can, I guess, overcome this barrier. They have a variety of dispute resolution methods to help young people. So even youth law aside, you've got things like mediation, you've got things like conciliation, arbitration, tribunals, complaint bodies. You've got lots of different places you can go to before you have to go to court. So that's why civil can be seen as a bit of a more accessible method. Many methods that we're going to look at or have looked at are low or no costs. So for example, Consumer Affairs Victoria, completely free to use. That helps to address the difficulty, helps to remove the barrier for people. To wrap up this particular part, I guess it's really important to know that, it can be a bit information loaded. There are 3 main institutions you need to look at. So like I said, I really want to stress that point one more time. When you see the word institution, we've got to be thinking of tribunals, ombudsmen, or complaint bodies. Try your best to remember an example of each institution. It can really help to explain your answer in a little bit more detail to beef up whatever it is you want to talk about. With the difficulties faced by groups, just remember there's those 4 groups you can pick. Like I said, make sure you focus on the one your teacher has stressed. Some teachers will get you to focus on all 4, some will just get you to pick one, but just make sure, don't just focus on young people if your teacher has asked you to look at low socioeconomic as well. And the very last one is applying the roles of the jury to case studies. So this is one quick point I want to stress, that often in a SAC you'll get asked a question about, outline 2 roles of the jury in reference to the case. Make sure that when you are talking about the roles of the jury and you do have a case study in front of you, you're always trying to link to the case study as much as possible to include it in your answer. You don't want to just list general roles of the jury and don't link to whatever the stimulus material you have. So hopefully that was helpful, guys, and I'll see you guys in the next video. Bye.